Good morning and thank you very much for joining us. I am Yori Folari alongside, well, I was going to say Asukwo, but no, it's not Asukwo, it's Cyril.
Thank you. Thank you. I'm glad to be here. Cyril, a very good morning to
you. Indeed. Great to have you on the show. Serious business, you know, especially in these times of the new normal we have, COVID-19 and all of that. Well, the Company and Allied Matters Act, you know, as amended was the bill was signed by the president, and the whole purpose of that, we should be speaking with, you know, the presidency to find out. Well, most people know it, but generally speaking, is to enhance the ease of doing business in Nigeria. Let that also be part of the new normal, and especially when you look at the situation that we are in. Close contact is not always possible. All those things are taken care of. Enhanced protection of minority shareholders, all that's taken care of. Things like who exactly is in control of this company by way of shares financially? Those things must now be, you know, obvious. So all of those are things that you can look forward to. And let's start off with a report. We have a report by Lara Afolayan.
The president only recently gave assent to the amended Companies and Allied Matters Bill. The Corporate Affairs Commission is now to unveil new regulations for business registration. Though pleased by the development, the Trade and Investment Authorities do not want it to put any strain on government's ease of doing business efforts. It wants the CAC to ensure the public has it most easy with business registration now that there are new legislations in place.
We're very happy that it has finally been signed. It's something that has been long awaited, and it is something that will also improve our standing on the World Bank Index of the ease of doing business, as government is trying to help SMEs to flourish, and as such, government is trying to see to it that anything that will make it difficult for them, government is trying to remove those impediments.
The Corporate Affairs Commission assures that the new document will be of benefit to the Nigerian business community. It says it is working with the legislature to ensure that the laws are quickly gazetted. The CAC is also coming up with regulations on articles, which it expects to bring about a better governance structure for companies.
There are so many changes, and most of these changes will come by way of regulations that will define how certain transactions can be done, who should do what, how these things can be done, particularly regulations on model articles of association. What we had in the former law wasn't extensive enough. Companies had been complaining because the provisions were not all-encompassing.
I look forward to the regulations that you want to put together. Once they're ready, we'll go through them again together, as you very well know, and we'll make sure that they are such that will continue to help with the ease of doing business and will not put too much hardship on the practitioners.
The President's assent to the Company and Allied Matters Bill 2020 repeals and replaces the previous one and also introduces corporate legal innovations that makes it easier to do business in the country. Lara Afolayan, TVC News, Abuja.
Okay, so there we have it. Thank you very much to Lara Afolayan. Well, the bill having been assented to, I guess we can now safely call it a law.
A law.
Or an act.
Yeah, sure.
Yeah.
And, you know, it's one of the things that we were awakened to with the reality of the COVID-19 pandemic. Businesses couldn't hold virtual meetings. There was just so much that was analog about our way of doing business.
Yeah, and you didn't know the extent to which you'd be in compliance, or you'd be compliant.
Yeah, exactly, exactly.
People coming up with their own devices. Okay, well, you know, there's a way in which we talk about our man in the presidency. Talking about the senior special assistant to the president on public affairs, Mr. Ajuri Ingilali. Good morning, Ajiri.
Good morning, Uncle. Good morning to all of our viewers, I guess.
Good morning. You see, I went and added another caption there, in addition to your official one. Anyway, great to hear from you. This should be very exciting to the business community. The bill that has been assented to the president, so we now have a CAMA Act or CAMA Law 2020, right? Oh no, the phones are not going to do it like this. They're not going to do us like this, are they? Let me try again, Ajuri. If you're still there, I was just saying that now that the president has signed the bill, we can now roll, as it were, with the CAMA Act of 2020 with its new provisions designed to enhance the ease of doing business.
That's right. That's right. Thank you very much. So, the CAMA amendment, the Companies and Allied Matters Act amendment, is something that the act was signed. Now, really what it means for us is it's a deepening of all of the very difficult work that Muhammadu Buhari and his administration have done to really deepen the process of easing doing business in the country. You recall that, of course, 2 out of the last 3 years, the World Bank has named Nigeria the top 10 most stable nation in the world, the World Bank's ease of doing business rankings. Now, this is going to take us further in that direction through a multiple set of new kind of, interventions. First of all, the CAMA amendment is going to allow for an up to 65% reduction in filing charges and business registration fees for upstarting MSMEs in the country that want to register their business. Think of that. There's a separate level of savings.
You know what, Ajuri? We're going to try and re-establish contact. We'll cut this and try and establish it with you again on a different line. This line is a bit wonky, as they say. So just, stand by for that. We're going to try and contact you again as in a jiffy. So starting off from there, and one of the things that Ajuri is going to be talking about will be the fact that I don't know how they did that, because normally you work on these bills for a long time before it arrives on the president's desk. But they have actually inserted in it things relating to the current global business situation, talking about the pandemic, COVID-19. Business is not the same anymore, yet there are regulations. And so it means that whatever they had been working on, what the thinking had dovetailed into, now we can't possibly go out without taking care of matters that, might be an impediment because of practices that have come about as a result of COVID-19. For instance, the annual general meetings, he's going to talk about that, no doubt. Those are kind of devices that have been amended, now, before, if anybody said that they did a remote meeting, I'm sure by the time they dragged each other to business court or commercial courts, there will be all sorts of issues. But now it's being written down. So it's all about, especially for the business folk, making it easier.
No, you see, let me even pick one of the benefits of the law. Mm-hmm. So for instance, we talk about foreign investors. Then there's a director who resides in Japan or China or Australia. When it is time to sign the papers, we will courier one sheet of paper from Lagos, from one end of the world to another, to Australia, to wherever he is in the world. He will append the signature on it. That's in paper. You shouldn't go missing, If you have to fly it back to wherever it originated, and then all the signatures that ought to be on it will get on it. That is the same paper that you submit to the CAC. So I think that if before now we didn't wake up to realize that we had cogs in our will to progress, right now this pandemic has taught us that look, you can't have. It's not even a return to the old order. It is actually a movement to a modified order, which is what law must help us to do. And this is what CAMA 1990, after a solid 30 years, in fact, some people have described this as the single biggest business legislation that's taken place in Nigeria in the past half century or so.
Indeed. We have Ajuri again on the phone. Ajuri, hopefully this is a better line.
Yeah, this is much better now.
Thank you. We can hear it. So I sort of had to interrupt your flow because of that. But you were telling us some of the high points of the new legislation, especially as it relates to, small businessmen, perhaps. Did I speak too soon? Did I speak too soon when I said this was a much better line? Ajuli, can you hear me?
Yes.
Okay. Yes. You were talking about some of the key points of the new act And maybe as it relates, especially, of course, it's about business, but is there anything in there for the small businessman? Does it make his life a bit simpler than it would have been?
Absolutely. First of all, with the up to 65% reduction in filing fees and business registration charges in the Corporate Affairs Commission, that's a major savings up front. And then there's a secondary level of savings because the CAMA amendment also removes the mandate that was placed on those registering businesses to, of course, obtain the services of a lawyer or a notary public to attest to their statement of compliance. Now, with this amendment, they can attest to their own statement of compliance, increasing that financial savings even further. But in addition to that, I think it's also important to note that it's not always about the financial savings, but also about time savings and efficiency. So also what we've done is to now allow for single directorship of companies, where individuals will be able to register their company without looking for friends and family to announce board of directors or anything like that. Now can do that independently. I think that's good.
And that's a remarkable one. Oh, by the way, Ajuri, sorry, I neglected to tell you, I'm in the studio here with Cyril Abaku, my colleague. So in case you hear a different voice and a question, it'll be Cyril Abaku. Now, that single shareholder, single directorship. Speak a bit about that.
Yes, no, it's very, very important because really, when you're adopting a business as a startup, and you know that your company is essentially centered around services you individually provide, at least at inception. It's very important to know that you can go and very easily, go and register your business without thinking of, how to involve other individuals who may have nothing to do with that you want to conduct now, moving into the future. And so when we talk about the process of, expanding a business further down the line and all of that, we've also taken into cognizance the current reality of, obviously, in 30 years, a lot of technological innovations have taken place. Obviously, broad-based of the internet, broadband, etc., since 1990. And so now a provision for virtual annual general meetings to be recognized by CAMA under this amendment, allowing for some of these virtual meetings to take place, effected as such and recognized by law as such. And moving forward, I think it's also very important that we also note that the very critical anti-corruption instrument Buhari has put in place is also to ensure that there is now a mandate that registering a business must declare the beneficial owners of shares of that company, the shares of the company being registered. Number one. Number two, where they are not, the director is not the beneficial owner of the company, they are now mandated to declare the person who nominated them who is the beneficial owner of the shares of that company. Because we all know that the trillions of naira that we have lost in this country over the decade comes largely as a result of companies that are serving as fronts for officials to be able to defraud people of this country. And so this is going to be a major source of ensuring that type of activity is nipped in the bud.
Now, you think of authorized share capital when people think of coming up with a company. Now they say this will be replaced by a statement of compliance, which since the whole bill is designed to make business easier, how so in this case?
Well, there's no doubt that having people, giving people the flexibility to attest to their own statement of compliance. Aside from what I mentioned about not having to obtain sometimes what can be expensive services for a lawyer or the notary public. It also is again part of that process of just making the process easier. That people can even on a whim go and register a business. And I think it's also important to note that the country, the economy that President Muhammadu Buhari is building is based on the ingenuity and hard work of individual and groups of Nigerians. What do I mean by that? When you look at all of the steps that have taken as perspective, diversifying the economy. We're moving into the labor-intensive sectors of agriculture, solid mineral production, and several of the other things that have been going on, construction, manufacturing, labor-intensive sectors, as opposed to the capital-intensive but non-labor-intensive sector of oil and gas, for example. You'll know that it is very critical that we give every motivation possible to MSMEs in this country. And that's why I think we should note that even as we're having this conversation on CAMA amendment, let's also note that on January 13th, this year, President Muhammadu Buhari signed into law a very critical legal instrument known as the Finance Bill, which has now also taken the company income tax obligation of all MSMEs in the country earning annual profit of between 0 and 25 million naira, 0% company income tax obligation, whereas they were paying it before. And that's secondly, scale enterprises in the country earning between 55 million naira and 100 million naira in annual profit, I have now seen a reduction in their company income tax obligation from 30% down to 20%. So the president is not just concerned with making sure that we ease the process of registering businesses. He's also concerned with ensuring that the operation of those businesses, once they are in operation, is eased in such a manner can reinvest the resources they would be paying to the tax authorities in expanding the operations and employing more Nigerians so that we really deal with the unemployment process as we're diversifying the nation's economy.
You know, I was going to come to this point that you mentioned, Ajuri, and ask whether this is related to what the vice president was working on, because his office has also had this focus of, easing, the hardships, the difficulties, the challenges of doing business, generally making business, easier, so to speak. Not that business ever is easy, but you get my meaning. Is it related? Now, this is like the CAP. There's the Company and Allied Matters Act. Is this related to the efforts of the Vice President's office towards the ease of doing business in Nigeria?
There's no doubt about it. Thank you very much, Yuri. When you look at the Presidential Enabled Business Environment Council, under the office of the Vice President, His Excellency William Yoshibato, there's no doubt that a lot of work has been done over the last 5 years to get us to the point where, of course, the World Bank has named us as the top 10 most improved nation in the world on the ease of business rankings globally. And if you look at how it has been attacked over the last 5 years in terms of the positive business, you look at all across the board, from the executive to the legislature to the judiciary, to reforms that have been put in place over the last 5 years. For example, in the executive branch, we all know about a lot of what has happened in the Corporate Affairs Commission, not just with the CAMA amendment, but even before now, in terms of reducing the time lag in terms of registering your business name down to even 48 hours, automating the filing within the FIRS. That's just the executive. You look at the legislature. We passed the Credit Reporting Act. We passed the Collateral Registry Act, which allows for MSMEs to essentially use movable assets like tractors, etc., as collateral to obtain loan facilities from banking institutions in the country. That has also eased the process of accessing liquidity for our MSMEs. And then if you look at the judiciary, of course, the two commercial courts in the country that talks about CAMA and Lagos, those high courts were able to establish and implement new compliance, created new alternative dispute resolution mechanisms, such as, of course, mediation, to reduce, again, the time lag of resolution of small claims, conflicts within those jurisdictions. So all of these things are those things that the World Bank came in, assessed on the ground, and said, look, these people are serious now. And they have actually rated us as such. Again, to your point, we have done a lot of work already. The CAMA is going to deepen that. But then we're not just focused on just the environment. We're also focused on making sure that there are real-time interventions for MSMEs. And that's why even if you look at the Economic Sustainability Plan of 2020, you would also look at MSME interventions we're making. So we have the Survival Fund, where we're getting ready to launch now, going to essentially supply 300,000 MSMEs with a survival fund, that is the payroll support, that will allow us to avoid the extinction of over 1 million jobs within MSMEs across the country during the difficult time of COVID-19. So we are looking at this from every angle, and we're attacking it as such as an administration.
Okay, Ajuri. Cyril has a question.
Okay, so Ajuri, I believe you have seen a video that has gone viral about church leaders saying that some aspect of the law is not something that they are very comfortable with. For instance, the government going to appoint trustees for churches. Could you take us through the relevant section and what exactly is there? You know, the fillers we're getting, are they what we're getting, or is it different from what the law actually provides for?
Thank you very much. Well, you know, we're in a very, obviously, we understand the climate and the environment that we're talking about. Obviously, Nigeria is a very diverse country where there are a lot of sensitivities, particularly when we begin to talk about state-based institutions and all of that. It's important to note that the reference that's being made is to the what was CAMA Part C, right, where it deals with charitable organizations, non-profit organizations, and the like. Now, there is, if you look at what has been done in the amendment, first of all, it does not exclusively deal with churches, even though there are some individuals who will want you to think that this is some sort of attack on churches, which is ridiculous, because it's really all institutions. That includes mosques, all sorts of associations that even have nothing to do with religion. This does, in effect, is it says, look, if the courts, right, have cause, for whatever reason, if there's maybe an investigation going on, or there's some sort of evidence that has been presented, or anything like that, a court must issue a order, right, that would now enable a set of processes to unfold, where if it has been proven that some sort of maybe money laundering, some form of fraud, some form of diversion taking place in some of these charitable nonprofit organizations, that then the Corporate Affairs Commission will be able to, of course, at that point, be able to get involved and ensure that there's a bit of regulation to see that there are some non-aligned actors who can see what's going on. If you look at how AMCON, for example, deals with, just look at what happened recently with Eric Air, where there was some allegations of corporate malfeasance, etc. They lost and all of that. They were able to determine that with evidence on the basis of debts owed, for example, and can now appoint a administrator to now take over the affairs of that company, for example. It's obviously different in the sense that it now gives power to authorities to be able to ensure that charitable organizations are not being mismanaged to fronts for government corruption or other forms of corruption, where in some of the religious institutions you have overseers of some of these institutions using the funds taken by parishioners to build all sorts of private institutions, profit-making institutions, and all of that have nothing to do with that church or mosque.
Okay then. Well, Ajuri, as always, I'm going to have to thank you very much for making time for us and indeed, clarifying a lot of those issues, or as it were, informing whoever was not even aware that this had happened, this monumental thing in the business community of the president signing the CAMA Act of 2020. Thank you very much, Ajuri Ngilali.
Thank you very much.
Pleasure. Okay, so there we have it. We'll open the phones, maybe in case there are some comments, commentary on this whole matter.
Mm-hmm.
But also, we sort of use the opportunity to say that we now have a date for when international flights
will be resuming.
Will be resuming
Yes.
in Nigeria.
Yes.
So all those countrymen and women, for that matter,
who are itching to get back.
Who have been stranded abroad, although stranded is not the word. You know what I mean. Mm-hmm. People who had gone and whatever. So suddenly now, from what?
August the 29th?
Yes. The end of the month,
Mm-hmm.
but August 29th. And so it's going to be business. Well, not so much business as usual, but business.
Business in a modified sense.
Yeah,
Yes.
yeah.
We should never aim to go back to where we were before.
It won't be business as usual.
We should never aim to, to go back there. We should aim to go higher and better. And
Okay,
here's
the Minister of Aviation, where he actually, actually announced it.
We are very glad today to announce that international flights will resume from the 29th of August 2020. It will start just like we did with the domestic. It will start with Lagos and Abuja. The Protocols, procedures, and processes will be announced in due course. However, what we have become used to, physical distancing, wearing of masks, washing of hands, temperature taking, etc., will continue. In the beginning, there will be 4 flights into Lagos and 4 flights into Abuja daily. We'll give further details on that in due course. And to say that this is a decision taken by the PTF.
Okay, so there we have the outlines of the matter. 29th, it is, so that's just to one side. A lot of people, but as you were saying, it's not going to be business as usual. We're not returning to those days.
It in fact shouldn't. In fact, this whole thing should now give us a new way of life. If before now we've been carefree in our public hygiene.
Sorry to interrupt you. Gabriel has called in from Port Harcourt.
Okay.
No doubt wanting to talk about the company and allied matters. Good morning, Gabriel.
Okay, good morning. How is everything?
Very well, thank you.
Good morning, sir.
Yori Folani and Cyril Abaku in studio here. What did you want to talk about?
Okay, yes. I wanted to get some clarification on some of the issues.
Okay, the Company and Allied Matters Act.
That church members have been saying as regards the CAMA bill. Because I've read through some of the issues around it, and it's actually a welcome development for the business industry. But I need some clarification on what effect does it really have with the Christian food, because from what I'm seeing, based on the current situation in the world, it has given a new horizon for the business and the industry. So I want some clarification on that, because there's this speculation that is going on that it's a bill that is anti-church. So I just want the guests to be able to give me some clarity on that, and as many that needs to get that clarification. Thank you very much.
Indeed, thank you very much for calling in, and we just, that was just a little, that international flights thing. We're talking about the CAMA thing. That will be a subject of another conversation. Ajurin Gilali, the senior special
assistant to the president,
on these matters, he actually spent quite a bit of time on that, explaining away this apprehension that yes, it is known and there are wrong notions about it. He was explaining, and I'm sure you could also research it further yourself, you could Google it, that it has nothing whatsoever to do in a negative way with religious houses or targeting of religious houses. I don't think I can say much more than the special assistant to the president said there on this whole matter. But he did make the emphatic statement that it has nothing to do with targeting any religious grouping body, whether Christian. Although you were particular, your inquiry has to do with Christians, but it doesn't matter what faith. It has nothing whatsoever to do in targeting them in any injurious kind of a way. No doubt, you Google the matter, you'll find out a lot more about it. Mr. George, good morning. Thank you for calling in.
Good morning, Uncle Yori.
Good morning.
And greetings to Siri.
Good morning to you, sir.
Uncle Yori, I would prefer to talk on the air travel, since I don't have details about the new law.
Okay.
So I really cannot comment on that now.
Okay then. Fair game.
Uncle Yori, you recall that this COVID-19 disease came to Nigeria through another man that came from Italy or somewhere.
Yeah.
That traveled through the airport. Now that we are in a hurry to reopen the airport, what arrangements have we put in place for people coming from other countries, especially countries that are deeply infested by this disease, that might retransport it back to our country? I want to know. Those details need to be made public.
Yeah.
Thank you.
Thank you very much for calling in, Mr. George.
I think the least we could do...
the Minister of Aviation was saying that apart from the initial rudimentary matters that he had spoken about, no doubt they will be very, very well aware of what Mr. George has just pointed out. And so, as he was saying, we need to know and be reassured that we got to act together.
The minister did say details will be released to the public in due course, and that for starters, four flights into Lagos, 4 into Abuja.
Yes.
So, you know.
We got to quickly go on a break now, but stay with us, please. We'll be right back. Might even continue on this before we go on to the next subject. Okay, welcome back. We had to rush off to break, but just to sort of draw the line under it, that subject will no doubt will be coming forth on the issues that Mr. George raised as to total safety. No doubt they wouldn't have opened up the airspace if they hadn't really been exhaustive on those areas. I would not to say that's the way I feel about it, and most Nigerians will feel about it. That they wouldn't have done this opening if they hadn't been exhaustive in their preparations for it. Now, moving on, the Election Tribunal nullified the Bayelsa governorship election yesterday, and so Governor Diri and his deputy, by that pronouncement of the tribunal, actually ceased to be, governor and deputy governor, and the tribunal ordered fresh elections be arranged within 90 days. Now, all of this matter has gone to appeal expectedly. They've quickly, time is of essence in this kind of a thing. So they've quickly gone to court to appeal the ruling of the tribunal. So this is where we are at now. The shocking news yesterday that, this was just a day after the governor had gone to a Thanksgiving service, or Tuesday, was it Tuesday? Just a day after a Thanksgiving service. Come and say that the whole matter is, it doesn't exist
on
anymore.
Saturday, 3 petitions were dismissed.
That's it. And then on Saturday...
And then by Monday...
Sunday there was a Thanksgiving.
And then by Monday, another bombshell drops.
The election, by the pronouncement of the tribunal, doesn't exist. It is not in place anymore. And fresh elections have been ordered. And there must be an inclusion of the party that actually went to court and complaining that it was excluded. Okay, we have Mr. Festus Okoye, INEC National Commissioner on Media and Voter Education. Mr. Okoye, good morning, sir.
Yeah, good morning.
Thank you very much for making time for us. As I've stated the case, I imagine, the INEC is well aware that there's been a pronouncement, but they have also, the party has gone to court to protest. Now, where does INEC, what does INEC now, what's going to be INEC's position? Because INEC by the tribunal was ordered to conduct a fresh election in 90 days. So where exactly is INEC in all of this? Is it going to wait and see?
Well, the law as it is today says we must wait and see. By the provisions of Section 143, subsection 1 of the Electoral Act 2010 as amended, makes it very clear that even if a tribunal nullifies an election, or even if a court of law nullifies an election, that the Independent National Electoral Commission must wait for a period of 21 days to elapse before we give effect to the judgment of that particular tribunal or that particular court. So the party that lost at the tribunal has a period of 21 days within which to appeal. And the law is that the incumbent remains in office for that particular period, pending the determination of the appeal. But if 21 days elapses and the party does not appeal, then the Independent National Electoral Commission is under a constitutional and statutory obligation to proceed and give effect to the judgment of the court or the tribunal.
Which is arrange a fresh election within 90 days of the pronouncement of the court or tribunal.
Exactly.
Now, the tribunal found that INEC was in error in the whole affair to not have allowed a party participate in the election. What would you like to tell us about that?
Well, there are basically 3 fundamental issues that are involved in the judgment of the tribunal. The first relates to whether the issues that the political party complained about is a pre-election matter, and whether the Election Petitions Tribunal has jurisdiction to even entertain that particular matter. As far as the Commission is concerned, the issue is a pre-election matter. and by the provisions of Section 285, subsection 9 of the Constitution of the Federal Republic of Nigeria, such a matter must be filed within a period of 14 days of the accrual of that particular matter. And I say this advisedly. This is because on the 13th day of September 2019, the Independent National Electoral Commission wrote to this political party, drawing their attention to the fact that they nominated an underage candidate as their deputy governorship candidate, and also drew their attention to the fact that under the provisions of Section 177B of the Constitution, a candidate for the post of deputy governorship of any political party must be 35 years or above. So, and we told them that their nomination was invalid. On the 21st day of September, the political party responded to this particular letter and agreed that their nomination was invalid, agreed that they nominated an underage candidate, and then forwarded the name of one in nowhere, Janet, as a replacement. Now, then on the 27th day of September, the commission responded to the said letter and told them that the period for nomination of candidates had elapsed on the 9th day of September 2019. And to that particular extent, they cannot substitute a valid candidate with an invalid candidate, and that their logo and their name will not be on the ballot. So, by the provisions of Section 285, subsection 9 of the Constitution, the cause of action accrued from the date the commission told them that they will not be on the ballot. So, to that particular extent, they ought to have filed their action 14 days from the 27th day of September 2019. They didn't do that. The second issue that arises from here is that this particular election was conducted on the 16th day of November 2019. The declaration of results was made on the 17th day of November 2019. By the provisions of the same Section 285, subsection 5 of the Constitution, any individual, any political party, any candidate that is agreed with the outcome of the election has a period of 21 days from the 17th day of November to approach the Election Petitions Tribunal. They didn't approach the court on that day. So there are two jurisdictional issues involved. And as far as this particular commission is concerned, what happened at the Supreme Court in relation to the pre-election matter that was filed is that judgment was delivered. But the provisions of Section 285, subsection 5 of the Constitution talks about the declaration of results. So that is when the cause of action accrued. So there are two jurisdictional matters involved. So what we expected the election tribunal to do is to assume jurisdiction and make a determination whether it has jurisdiction to even entertain the matter in relation to the fact that it is a pre-election matter, and also in relation to the fact that the period for the filing of election petitions had elapsed. So on these two jurisdictional issues, the commission, as far as we are concerned, is on firm grounds, and the majority judgment of or the split judgment of the election tribunal, as far as we are concerned, did not address the substance of the petition.
Well, in fact, because I was going to ask, since you explained so clearly the first jurisdictional issue, I was going to ask if you were surprised that they had found as they have found, bearing in mind you've taken it step by step, all the issues that are involved, but clearly it would be that you are indeed surprised.
Yes, we were surprised because my first predilection is that a political party that wants to govern a state does not know the constitutional requirements for contesting governorship election. That's the first issue, and it's fundamental. Secondly, the provisions of Section 31, the proviso to Section 31, subsection 1 of the Electoral Act, is dependent, is subject, is inferior to the provisions of Section 285, 14C. Mm-hmm. Section 285, 14C provides that, it says, for the purposes of this section, pre-election matter means any suit by a political party challenging the actions decisions or activities of the Independent National Electoral Commission disqualifying its candidate from participating in an election, or a complaint that the powers of the provisions of the Electoral Act or any other applicable law has not been complied with by the Independent National Electoral Commission, in respect of the nomination of candidates of political parties for an election, timetable for an election, registration of voters, and other activities of the Commission in respect of preparation for an election. So this particular provision is superior to the proviso to Section 31, subsection 1 of the Electoral Act that the Tribunal also relied on.
Okay.
It is incongruous.
Okay,
it is incongruous for the Commission. Yes.
Mr. Koye, one second, please. One of our viewers has called in. Let's hear from him. Mazi Okoroafo in Imo State. Good morning, sir.
Mr. Yori.
Yeah.
Yeah, Mr. Yori, I want to find out from Mr. Koye, sir. Now, we have seen what's happening. What does it take the federal government to sign the electoral law? Now, that you see, what the INEC is saying now every day is different from what we have in electoral law. Because if the federal government is to sign the electoral law, that will make us somewhat. Now, look at the judgment. There are 3 judges. 1 said no, and 2 said yes. Now, under this contradiction, it's creating a lot of problem because we don't know the last part of pandemonium that because now when we go back again to Supreme Court, the Appeal Court. Now, how do we solve this problem? Does it mean that INEC has no power to tell the federal government to sign the electoral law now or never?
Okay, thank you, Mazi. Mazi, let's keep it short and sharp so that Mr. Koye can relate to it. Thank you very much, sir. Festus.
Yes, the issues involved in the other judgments he talked about are slightly different from the issues involved here. In one of the judgments that was delivered, one of the complainants or the petitioners complained that the deputy governorship candidate forged his NYC qualifying NYC certificate, and the tribunal found that was not true. So the issue in relation to that one is different. Now, in terms of signing the Electoral Act, the provisions of the Electoral Act is not really germane to this one. This is because the Constitution is the fundamental law of the land. It is the ground norm. Every other law derives its validity, derives its supremacy from the provisions of the Constitution. And any provision of any other law that is in conflict with the Constitution will be declared null and void to the extent of its inconsistency. And so the provisions of the Constitution has given the Commission the power to do what it has done. And any other law that says that the Commission does not have such power is inferior to the Constitution and is null and void to the extent of that inconsistency.
But as you said, Mr. Koye, the Commission has to wait and see. By law, it has to wait and see what indeed a superior court shall say about the matter. And in the meantime, Mr. George has called in from Ikeja.
Okay, good morning again.
Okay then, good morning.
I'm sorry, I have to call back. The INEC commissioner said something that elicited my reaction.
Sure.
He said that the political party in question wrote to substitute their candidate. And they replied to the political party that for whatever reason they cannot substitute their candidate.
It was out of time.
Yes, and then said the party, that party will not have a candidate in the election. That is the bone of contention. That is what the judgment was about. If the INEC said that the party is not qualified to substitute, what they should have done is to put the original candidate that party
sorry,
ballot.
Mr. George. What Mr. Koye explained, unless I got it wrong, was that they submitted a replacement out of time. There was a time frame within which they could do that.
Even if that was the case, they shouldn't have said for that reason the party will not participate. Okay. They will say only the candidate is submitted on time will participate. That's why that party went to court, and that was what the
but under what law is this one, Mr. George? This one you are suggesting. Under what law or regulation?
No. If you say you are substituting and you didn't substitute at the right time, then the former candidate you favored should subsist.
Okay.
That is what common sense dictates.
Let's hear from Mr. Okoye.
Yes, I understand what he's saying, but my short response is Nigeria is a constitutional democracy, governed by the Constitution of the Federal Republic of Nigeria, 1999 as amended. And Section 177B of the Constitution of the Federal Republic of Nigeria states clearly that a person shall be qualified for election to the office of a governor of a state if B, he has attained the age of 35 years. Now, if you also look at section 187 of the same law, it provides that the provisions of this part of this chapter relating to qualification for election, tenure of office, disqualifications, declaration of assets and liabilities, and oath of governor shall apply in relation to the office of governor, of deputy governor, as if reference to the governor, we are reference to the deputy governor. So wherever governor is mentioned in the constitution, deputy governor is mentioned. They are CMS twins, they are inseparable. If one person falls, the other one falls. And the implication is that in fact, it is next to impossibility for the commission to agree for any political party to field an underage candidate. The implication is that if a political party puts in his affidavit that his deputy governorship candidate is a year old, that the commission should fold his hands and do nothing. Or if a political party nominates a Ghanaian or a Chinese or a Filipino and states in affidavit that they have nominated a Filipino, we should fold our hands. When the constitution says that only a Nigerian citizen by birth can become a governor of a state. The commission is a regulatory agency, and the constitution has given us power to make sure that political parties do what is right and conform to the provisions of the constitution of the state.
So INEC, Mr. Koye, INEC was being rigorous in its adherence to the law, to the rules, to the regulation concerning this issue, is what you're saying.
Yes, you see, one mistake political parties keep on making is that when we release our timetable and give the last date for the submission of nominations, they will wait until 5 p.m. when the closing date is 6 p.m. of the 9th of September before submitting the applications.
Okay.
And if anything goes wrong at that time,
it leaves them very little wiggle room. Okay, let me bring in another viewer. I'm sorry to interrupt you. Mr. Yakub in Dokwemu, good morning, sir.
Yeah, Jibiori, good morning, sir.
Yeah, quickly, please.
Jibiori, one, I go with Mr. George for one reason. Let me give you an example here. I think we have been in this program for almost 20 years now. I mean the politics of the thing. See, Jibiori, we have had this thing time without number that INEC have no power to disqualify any candidate. I want to know, and then you should put that question straight to the INEC spokesman. They have the power to do so. That's number one. Number two, if you look at the concluded election in Bayelsa State, the candidates of APC, they were disqualified in the court of law because of the deputy governor, because of the issue that it has with their certificate and everything. And then they still allow them to participate in that election. Now, the two judges that say something that they have no right to disqualify this very particular candidate. And then one out of the three judgments says that the INEC have right to do so. Are you telling me the two judges in that panel, they don't know what they're saying? So INEC chairman INEC spokesman rather should tell us where they derive their power from to disqualify any candidate for participating in election, because they should be leaving them.
Sir, Mr. Yakub, I hear you, sir. But surely a candidate must qualify, but it's not my business. Mr. Okoye is there. Mr. Okoye, INEC has no power whatsoever to disqualify any candidate whatsoever.
Let me just explain two things to him. The first thing I need to explain to him is that even if the commission was wrong in the action it took, the law is that the right of action for the person disqualified or for the political party disqualified to go to court arose on the 27th day of September 2019. And the law says that they must file their matter within 14 days of the accrual of that particular matter. That is one. They didn't do that. They waited until February 2020. The second issue is that even if election had been concluded and they still felt that they had a right of action, they still feel like I agreed. Section 285, subsection 5 says that they should also file their action within a period of 21 days after the declaration of the results of the election. They didn't do that. So we are saying that on these two grounds, the court doesn't even have jurisdiction. Then even on the ground of whether we were right or not, we are saying that what they did was that they nominated an invalid candidate. And we drew the attention to the fact that they nominated an invalid candidate. And they wrote back saying, oh, okay, we realized that we nominated an underage candidate. Can we replace that underage candidate? And we said, no, you can't replace, because the period for the nomination of candidates had elapsed. And by law, if the period for nomination of candidates has elapsed, you can only substitute on two grounds. One, if the candidate you nominated is dead. And two, if the candidate you nominated voluntarily withdraws from the race, then you can now nominate somebody else, and there must be a letter from the candidate saying, I have voluntarily withdrawn from the race. In this instance, that was not the issue here. There was no candidate that died, and there was no candidate that withdrew. The candidate in question had an invalid nomination, was not qualified ab initio, and the commission informed them that the candidate's nomination was invalid.
Okay, and your position, as you have explained it, is you wanted to be meticulous about the validity of the candidates. You explained, you even used the example of, should a Filipino have been submitted, for example, INEC would have complained. But in this case, the man was underage. The person was underage, and that was your complaint.
Yeah.
And that was why you took the action.
Yes,
we have Engineer Ekundayo in Kaduna wants to contribute to the issue. Good morning.
Good morning.
Please go ahead quickly. Good morning, sir.
Thank you. What I'm trying to say concerning this program is that INEC did not disqualify any candidate. What happened is that the political party disqualified their candidates themselves, because by not following the regulation, they are automatically out of contest. So INEC has not violated any constitution by disallowing them not to contest in the election. They disqualified themselves by law and regulation of INEC. Thank you.
Okay, thank you very much for calling in, Engineer Kundayo. But the situation we have on our hands now is that the tribunal and two justices there have found differently. There is one, perhaps, that is, so this is the situation that we have, and that probably is why the matter has gone on to a higher appeal. But we want to thank Mr. Festus Okoye for airing the issue a bit better for us, so that many of our viewers who were not among the select few that really had the nuts and bolts of the issue are a bit better informed now, if whatever their personal opinion is. At least they know the position of INEC and how INEC came to do what it did. Thank you very much for coming on, Mr. Festus Okoye.
I really appreciate this opportunity.
Indeed, our pleasure. So there you go. That's our program, basically. We've run out of time. Unless Cyril wanted to add something, because Cyril, before, maybe we can take a minute ourselves in studio now.
Well, what I would like to, I mean, we can point to the danger of what they call the judicialization of political process.
There you go.
Everybody runs to court to resolve every issue. We don't follow the process, the electoral process of doing what is right and getting our victory at the ballot. It's a danger.
Yeah, and it's going to be interesting to find to hear or to see or to know what the High Court pronounces. The two jurisdictional issues that Mr. Okoye pointed out. At the appellate level. Yes, and the time for them to act having lapsed. But still, there are eminent jurists, there are eminent judges who have said that in spite of all of that, they find that INEC was in error. So it's going to be an interesting one. So that's our program. Please join us tomorrow for a fresh edition. I am Yori Folarin alongside Cyril Abaku saying, do your best to keep safe. Bye-bye for now.